Hello and welcome everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational BenderU webinar discussing labor and employment law updates for 2022. Some housekeeping notes. At the end of this webinar, we will have an engaging Q&A session that I will be facilitating. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenters will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I'll be sharing other questions you might have with our speakers. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This class is being recorded. At the conclusion of the webinar, the recording link as well as a copy of the slide deck will be forwarded to you. We have two amazing experts sharing with us this morning, and I have the honor of introducing the first. Keck Royce joined Bender Insurance Solutions in 2013, specializing in the healthcare industry, property, schools, and nonprofits. She dedicates herself to education and studying risk management to better serve her clients. She is passionate about leading businesses to achieve their full potential. Keck has earned her designation as a Certified Insurance Counselor, CIC, and Certified Risk Manager, CRM. Welcome, Keck.
Thank you, everyone. I am thrilled to be here to provide the employment practice liability insurance market update and claims trend. So if we can get to that page, we'll get started right away. So that way you get to hear Trevor, who's way more important than what I'm providing. So what we want to talk about today is what falls under the in the coverages for employment practice liability. Typically, we see sexual harassment, discrimination, wrongful termination, and retaliation claims. We even see FMLA, ADA, and sometimes wage and hour claims. Wage and hour defense is included in EPL coverage. I do want to help everyone to understand that carriers are limiting sexual harassment definition to exclude sexual abuse coverage. This has stemmed from some of the social and legislative and legal movements that we've seen. So, for example, the Me Too movement have led to an increased claims activity regarding sexual abuse. So, and from there, we have seen legislative updates and laws changing to extend the statute of limitations regarding the reporting that a victim is able to have. And so victims are given more time to report on an incident and an incident of abuse that they have. So from this, we've seen a decrease or a limited definition of sexual harassment, and we do see a exclusion for sexual abuse. So if you have currently a policy that says sexual harassment, you'll see that that definition has changed throughout the years recently. In addition, wage and hour defense costs have become more limited in the last couple of years, and in fact, we see them removed altogether because of the increased claims activities. Regarding Black Lives Matter, we have seen more requirements and policies and procedures by organizations to include diversity, equality, and inclusivity. This is all very important social movements that are happening, and it's important to note that carriers are seeing board diversity claims stem from some of these movements. So if we can move on to the next slide, I can provide you an update regarding what we're seeing with COVID. The coronavirus has impacted us all. Your organizations have dealt with furloughs, terminations, and subsequent rehiring of employees. Underwriters have become concerned regarding COVID litigation. What we have seeing and what they're anticipating is the onslaught of wrongful termination and rehiring of discrimination claims. Unfortunately, this is just the beginning, and they anticipate more claims coming from this. Just so you know, I'm not going over every bullet point because we want to be able to move to your labor and employment law update. So we'll move on to the next slide. What are we seeing regarding the trends in employment practice liability insurance? Coverage is getting more expensive. Premium and retention levels are increasing anywhere from 5 to 30% is what we're seeing out there. Retention levels. What that is an employer or an insured is required to pay a certain amount up front before the carrier's policy kicks in. So what you have is retention levels increasing from 15,000 is what it was, and now we're seeing them as high as 50,000 or even 100,000. So this is a big change in what we're seeing. This is due to what we've seen regarding the large jury rewards that we've seen come out from some of these claims. In addition, carriers are starting to limit where they write their EPL policies. States like California, New York, New Jersey, Illinois are hotbeds for litigious activities. Unfortunately, even cities are becoming areas in which underwriters, insurance carriers are saying, no, we don't want to write in this area. Los Angeles and San Francisco is just an example of a few. So be aware that it's becoming more difficult to get coverage when you do want to purchase coverage. In addition, the application questions are becoming more extensive. Audits and company financials are required now. They're not just recommendations, they are actually required as part of the process. They're reviewing policies and procedures of your organization. They want to know if you're working with an employment law attorney or a firm. They want to understand that those policies and procedures are being reviewed by a qualified employment law counsel. What training are you providing your employees, your management, your leadership team? And surprisingly, they're even reviewing your website and websites like Glassdoor and Indeed. They want to review the comments there. If they're negative, these negative comments can lead to future potential claims, and they want to make sure that they are aware of these future claims. So there are many things that are changing in the employment practice liability market. Next slide, please.
Kek, we actually have a question for you.
Oh, you do? Okay, go ahead.
I do. The question is, does EPLI cover CFRA like FMLA?
It can. So with the recent changes in law, insurance carriers, you must ask the insurance carriers for these coverages because sometimes they're not just typically included. It does require your broker to work with the insurance carrier to request these coverages. Is there any additional questions?
So there was a follow-up question from another guest who asked, what is CFRA?
What is the actual acronym or the law?
She didn't specify.
Okay. So the FFCRA is for employers who are less than 500 employees that are required to provide FMLA or sick leave to employees who are dealing with COVID. So if your policies and procedures do not currently allow for that, make sure that your policy and procedures are updated to satisfy these regulations, these new laws. That first slide does talk about FFCRA a little bit more. I just didn't go into details about it, but I'm sure Trevor can even touch more on what the actual law will be about. He'll be talking about COVID as well.
Perfect. That's all for
Any
questions for
additional follow-up questions?
now. That's it for questions for now. Thank you so much.
Okay. And so just to finalize this, what can you do for right now? As a insurance purchaser, I 100% recommend that you review your policy for any gaps in coverage. Like I spoke about regarding the definition of sexual harassment versus sexual abuse, that's not covered, right? Sexual abuse is not covered. When you're in industries such as nonprofits, healthcare, or social services, you're more exposed to the potential of a sexual abuse claim. There, you do have the ability to purchase sexual abuse policies that are separate from an EPL policy, but understand that your EPL policy does not cover it. Make sure your choice of counsel is approved before that claim comes in. So for example, if you're working with Trevor right now, understand that you can go to your carrier and ask to get him approved. But you have to do it before the claim comes in and work with your broker to achieve this goal. Because if you don't do it before, when the claim comes in, you are having to choose from the panel of counsel that has already been pre-approved by the insurance carrier. So you might be out of luck in working with, for example, Trevor. I work with your broker to identify areas of risk. So if you're working with your broker to review some of your policies where your employees aren't following through, they'll be able to help you identify that there is potential claims that can come from the lack of following procedures, right? And then last but not least, if you don't have an EPL policy right now, understand what the cost is to protect your organization. What will it cost not to purchase an EPL policy, and what will it cost to purchase an EPL policy? And that's kind of my summary and market update for employment practice liability. I can answer any additional questions after Trevor's presentation, but at this time, it is my pleasure to introduce Trevor Hudson from Palmer, Constantian, Wool & Hodson, LLP. Trevor brings over 25 years in experience in advising in-house corporate legal counsel, labor relations administrators, and human resource professionals. He has represented executive management before federal and state courts and the National Labor Relations Board, as well as administrative agencies in aspects of employment law litigation. His representation has included such areas of expertise as wrongful termination, unlawful discrimination and harassment, retaliation, wage and hour, workplace violence, leaves of absence, breach of contract, and defamation. His expertise includes assertive use of alternative dispute resolution mechanisms to find solutions, including formal and informal arbitration and mediation. Trevor's professional affiliation include President of BYU Management Society, Sacramento chapter, President of J. Reuben Clark Law Society, the Sacramento chapter, the Sacramento Area Human Resource Association, the Folsom Chamber of Commerce. And at this time, please give a warm welcome to Trevor. Take it away, Trevor.
Thank you, Keck, for that wonderful introduction, and welcome all to the presentation today. Thanks for jumping online. I know this sometimes is not as convenient as being in person, but in other ways it's even more convenient. And we were talking beforehand that there's a lot more folks who can get involved, and so we hope it'll be somewhat interactive, because I know, at least for me, just talking at a screen is not as enjoyable as engaging with folks. So if you have questions, I'd love to hear them as we go along. And just a quick note on the employment practice liability insurance presentation. I'm a big fan. In our practice, we deal a lot with prevention and compliance and trying to keep things out of the court system and out of dispute resolution. But we still see a great deal of that, and have some excellent litigators in our firm that deal with this. And I can tell you there's a huge difference between those who have insurance that is strong and robust and helpful in those times when you do get that lawsuit. So I really encourage you to follow the advice and counsel of Keck on figuring out where you're at and what you'd like to do in the future. But a big fan of that. And the choice of counsel is excellent advice as well. I've had a lot of clients who've been frustrated when they couldn't use the counsel that they wanted to use and had counsel forced on them. So looking into that element of it, some have even felt like there was a bit of a conflict with those who were appointed by the carrier. And so figuring that out prior to any dispute, I think is really important. The last thing is just the California Family Rights Act is the CFRA. It does have some application to COVID, but it's a much broader law than that. And the leaves of absence we'll talk about a little bit in this presentation. There hasn't been a whole lot of change. There was a big change last year, but those leaves of absence and retaliation in response to those leaves of absence oftentimes will be included in a wrongful termination claim. So the EPLI, the Employment Practice Liability Insurance, does frequently have some coverage there with the leave of absence and the retaliation, wrongful termination associated with it. Okay, so what we're going to do today is walk through some of the trending cases as we start 2022. And I thought the best way to do that was to look at a few United States Supreme Court cases that are up for review by the United States Supreme Court that have to do with employment law and that touch California. So we'll start there. And again, we're looking at trends and trying to give you a good idea of what's out there and where you might look internally with your policies and your practices and your risk assessments on employment and labor law. So the first case that we want to talk about is this California Trucking Association v. Monta. This is a case that deals with something that many of you will probably be familiar with, which was AB 5. AB 5 is the law that makes it more difficult to be an independent contractor in California. Briefly, the AB 5 instituted, reestablished this ABC test, which is a three-pronged test that an independent contractor has to meet prior to AB 5 and some of the cases that were associated with it. It was more of a balancing test. You looked at the IRS had a 20-point test that you would look at, and you would balance what looks more like an employee, what looks more like an independent contractor, and balance it out. This ABC test goes in a different direction, and it says, no, there are three strong criteria that you have to meet in order to be a contractor. So it increased the challenge, the difficulty in being a contractor in California. The Trucking Association said that this law is too onerous and it should be preempted by other federal laws that govern interstate trucking. And the Ninth Circuit, which is the appellate court here in the California area on the West Coast, it decided that this California statute, AB 5, is not preempted by federal law, meaning that the law, the AB 5, would apply to the trucking industry. So that was a big hit to the trucking industry, and they have taken that case up to the U.S. Supreme Court. We're hoping that we'll get some type of decision by the middle of the year. But this case would be significant because if the ABC, AB 5 test is applied, then the trucking industry will have a very challenging time continuing as independent contractors for their truckers. The next case that's before the U.S. Supreme Court, again, you see that the Ninth Circuit is the one that makes that decision, and then it goes up to the Supreme Court if the parties take it there. But this one has to do with airlines, and it doesn't have to do with independent contractors, but it has to do with another state law. And that state law has to do with the meal and rest periods and the premiums that are associated with those rest and meal periods. Federal wage and hour law does not address specifically meal and rest periods. Lots of states don't deal with them either, but California has required certain meal periods and certain time frames each day. And then if you don't, there's a premium, like an overtime premium, that has to be paid. So the state, of course, wants to enforce those meal and rest breaks on flight attendants who obviously don't solely work in California. They're flying all over the country and the world. And so the Ninth Circuit has said that if the relationship, right, the work relationship, you see the parabola there, the most significant relationship to the work, if that's in the state of California, then even if they might go off in other places, this meal and rest period law could apply to them, which of course would increase the costs, right, and the challenge that an employer would have, an airline would have in trying to provide a flight attendant with these kinds of meal and rest breaks in certain hourly time frames. It also says that that it's not preempted by federal law. So it's not preempted by federal law, and there is some application in the state. So this again is a case that was decided by the Ninth Circuit, not favorable to employers, not favorable to the airline, is now being taken up to the US Supreme Court for a decision. The last group of cases that are up before the Supreme Court that touch California are these 5 cases. And these 5 cases, these deal with what's known as PAGA. Now, PAGA is the Private Attorney General Act. And PAGA is a state law that basically allows one employee to represent an entire workforce for any violation of the labor code, which deals with all these wages and hours, working conditions types of laws. And so it's if one employee can represent all of the workers, it's a lot like a class action. But the difference between a PAGA, Private Attorney General Act action, and a typical class action where one person represents an entire group of people. In this case, under PAGA, not only can you go over go after the lost wages, right, overtime premiums that weren't paid, meal and rest periods that weren't paid, other types of wages that were lost. You have that one employee representing for the entire workforce, which obviously amplifies that kind of dispute. But under PAGA, the employee can also pursue civil penalties that only the state could pursue. That's the idea behind it, Private Attorney General Act, right? It's basically the state saying we don't have enough time to go and pursue all these employers that are violating the labor code. So if you, one employee, are able to say that there's some problem in the workplace, then we're going to authorize you to represent us, basically, and go not only after the wages and other statutory penalties that you would be entitled to, but also the civil penalties that the state would be entitled to, and then the state takes a portion of that remedy. So these cases are attempting to say, in all of these cases, the employer has in place an arbitration agreement. And in that arbitration agreement, they have eliminated the ability of employees to pursue a class action. But the California Supreme Court has said that's fine. An arbitration agreement can eliminate those class action aspects, but they can't get rid of the PAGA claims, because the PAGA claim is a state action. It's really the state that's acting. And so in all 5 of these cases, the US Supreme Court is going to review that and decide whether an arbitration agreement can dismiss basically a PAGA claim and force employees to go through the arbitration route individually instead of in that representative action. This is a challenging area that has been looked at for several years in several different courts, both at the state level and the federal level. And so it will be good to get an answer to this question. And it's hard to know where this is going to go, quite honestly. There is a sound argument based on this idea that the PAGA claims are a state claim, right? They're a state that the government would, a claim that the government would bring, and they're not a party to an arbitration agreement. So that's what we're going to be looking forward to, and the idea of arbitration agreements is a bit up in the air because of that, and how broad they can be. And at the end of the day, we may be revising all our arbitration agreements at the end of the year based on some of these cases. So those trends, right? You see a lot of wage and hour and classification issues, independent contractor, meal and rest periods, and then penalties under the labor code. So I think this, as far as trends go, one of the things to keep in mind is, how is your payroll system? How is your compensation? How have you classified your employees, whether it's exempt, non-exempt, employee, contractor, right? These classifications and the way we're compensating folks is really at the heart of most of these employment law trends. And certainly in our office, the number of claims we see under this PAGA, which have to do with the labor code violations, is astonishing, right? It certainly rivals and may even have surpassed a lot of the wrongful termination claims that there used to be. So these wage and hour claims are really taking over, and they can be extremely costly. Because as you might imagine, right, one employee representing the entire workforce, and then on top of that, being able to go after all of the penalties that the state could bring against an employer, those are certainly multi-million-dollar kinds of cases. So that's the trend, and I think the answer to that is to really go back and audit and look carefully at how you're compensating and how you're classifying employees. Those are the Supreme Court case that impact California. Let's look at a few more California laws and some things that have happened over the last 12 months that we're going to be dealing with in 2022. We're going to start with some wage and hour, additional wage and hour cases and statutes. The first one is another preemption, and just I thought I'd throw this in at the very beginning here, but you start to see this conflict, right, between federal law and state law. So it's the last one was dealing with the with aviation and airlines. This goes back to truckers, and this is not having to do with independent contractor issues, but the meal and rest break rules. And in this case, the Ninth Circuit said that federal law did preempt meal and rest break rules. And so you see that employers are running to federal court to try to get some assistance. And in some cases, the federal court is saying, yeah, California rules are out of line and can't violate the federal law that's already there. And then in others, they're saying, no, federal law doesn't go that far and the state law does apply. So lots of confusion in this area, quite frankly. Similarly, this is a Walmart case. And in this case, it did have to do with PAGA. And so employees there at Walmart were trying to sue under California law for violations of the labor code that they found. But the federal court in this case, back in May, basically said the opposite of what the California Supreme Court had said, which is that if an employee does not have a clear cause of action, right, then that employee lacks what they call Article 3 standing, or the ability to bring a lawsuit, and the PAGA claim fails. That's in opposition to this case, which is a California appellate court case from back in July, in which the court said, even if the claims are time barred, right, because it's a state kind of claim, an employee can still be the representative. And so there, again, there's this conflict between federal and state law. There's this conflict between the employer and the employee. And these PAGA claims are right at the heart of it. So again, I think the answer to all this is really to go back and audit and make sure we are paying people properly and avoiding those labor code violations. Another trend associated with compensation that I wanted to bring out is this Equal Pay Act. So the Equal Pay Act deals with the disparity between compensation to men and women. And the federal law has been in place, and the state law, quite frankly, for a good period of time. But over the course of the last several years, we have seen the state law become increasingly broad in its approach to reviewing this disparity. And they've also added equal pay analysis, not just on gender, but also on race and ethnicity. And so this law is broadening. And in particular, in this case, you see the highlighted portion down there, they allowed statistical evidence to come into play. So in these kinds of cases, you're oftentimes looking, well, is the job, you know, in the typical case, is the job that the man has and the woman have, are they the same? Or are they substantially the same? And if they're not, then the disparity is justified. If they are, and there's a disparity, then that becomes problematic under the law. And so the use of statistical evidence, of course, will start to allow to see disparities that we might not be able to see without the statistical evidence. So again, this is a broadening of the concept of that disparity in compensation based on gender. My thought here is that, and we've seen this a number of times over this last year, the need to really go in and carefully review the compensation systems that we're using, and whether there's some historical disparity that has continued, or whether we have not really determined the similarity between positions that sometimes may be typically filled by one gender or the other. And so those kinds of analysis after a complaint has been filed are not helpful, right? The key is to look at this beforehand and try to determine whether or not we're in compliance with the law before, because then modifications can be made, right? And then if an audit comes or if a lawsuit comes, there's a lot of good evidence that we've recognized that we've done something about it, and we're trying to remedy the situation. So not just looking at you know, the difference between state and federal law and classifications and labor code violations, but I think also the disparity between gender and other protected classifications in compensation is a really important trend. I expect to continue to see this modification of the law and expansion of the law and broadening of this review. The next few slides are just dealing with a few different issues that we've seen, bigger types of trends. In this case, the Lowe's Hollywood Hotel case, the California Supreme Court made a determination that does impact premium payments for meal and rest. And all of the defense counsel that I know of, everybody in the HR world, assumed that the premium payment that was required for a missed meal period or a missed rest period was just the base hourly rate, right? If I get paid $10 an hour and I miss a meal period, the premium is, you know, $10 for that day. But this case decided, no, it's not the base hourly rate, but it's it's the term that's known as the regular rate of pay, as that term is used in the overtime premium setting. And so the overtime premium setting takes into account, this regular rate of pay takes into account the bonuses that might be paid or other compensation, meals that are provided, lodging that's provided. All of this gets added into the regular rate of pay. And so now all of that has to be added into the meal and rest period premiums as well. And that's a big change. And the holding also applies retroactively. So that is a broadening of labor code violations. Someone could have been paying the premiums on meal and rest and think they were doing it right, and then find out that they were not, which could then lead to these class actions, these PAGA claims, and all of the things we've already talked about. So reviewing and making sure we're calculating the regular rate of pay properly, we're including those bonuses in there, and that we are able to pay the premium properly, not just on overtime, but on meal and rest period premiums as well. Another case, an early last year that came out that had to do with wage and hour that I think is this concept of rounding. There was a case a couple of years ago that did say that it's okay to continue to round when you're dealing with time cards and time punches and the time records that you keep. And of course, this harkens back to old time cards when you had 50 people who needed to punch in at exactly the same time, and it was impossible physically to do that. And so you would allow for rounding. And basically the rule on rounding is you can round up to the 15 minutes as long as you do it fairly, meaning that sometimes it benefits the employer, sometimes it hurts the employer, but it's a constant, and it's done in a fair manner. In this case, the defense counsel took the idea and said, well, look, if rounding is appropriate at the beginning and ending of shifts, then rounding should be appropriate with regard to meal periods, right? And so if you let that 15-minute rounding occur, most violations would go away. A lot of the violations that you see in meal period litigation is a 29-minute break or a 25-minute break instead of a full 30 minutes. And so in this case, the California Supreme Court said no. Rounding may be appropriate in other settings, but it is not appropriate in meal periods. And 30 minutes means 30 minutes. And so again, kind of reiterating what we've talked about already, going in and auditing and making sure that our meal periods are the full 30 minutes and taken within that first 5 hours of the day. That's critical, because that's where most of these violations occur. When you get into those PAGA claims and class action claims, it's associated with not properly giving the meal period, either in a timely manner or for the extent of time that's required. And this case reinforces that we have to make sure that it's not just a 29-minute meal period, but it goes all the way through a full 30 minutes. A few more compensation-related issues. This one is a law that comes into effect, and it applies to the intentional theft of wages, being punishable as grand theft. And in particular, in my mind, it deals with gratuities, right? That's the place where sometimes an employer may not properly ensure that every gratuity that comes in goes to the employee. And that is state law, and failure to do that could be an intentional theft of wages. We also see another tip law here on food delivery folks, which I think is a clear indication of kind of the route that the trend that employment is going and compensation is going. And this is aimed, specifically at food delivery and facility personnel, that they are entitled to their tips. They are entitled to their gratuity. And if we don't do tips right, we could be subject to criminal law based on the two statutes. Another trend that I think is worth mentioning is the law just actually catching up with the rest of the world. But you know, we used to have bulletin boards and postings and things of that nature. There's less and less of that, especially now with a remote type of workforce that is occurring in a lot of workplaces. So the distribution of postings now via email or some other electronic means is the aim of this statute, and certainly appropriate based on the workforces that we have. Lastly, in this area, just a reminder that effective January 1, if you have 26 or more employees, the hourly rate, the minimum wage is $15 per hour. And if you have 25 or fewer, it's $14 per hour. Next year, everyone will go up to $15 an hour. And then after that, it uses a calculation to increase the minimum wage. So this isn't the end, this is just the beginning of the increases annually of the minimum wage. It just won't be as lockstep as it has. The other thing to remember on this, besides just the minimum wage for those who are receiving that wage, this does impact the salary basis test in California for exempt employees. And we have seen a number of employers who, as these increases have occurred, have not kept up with these salary tests. So in California, the minimum salary for an overtime exempt employee is 2 times the minimum wage for a 40-hour work week, annualized and then paid on a monthly or semi-monthly basis. So folks who are exempt, but their salary is right at that threshold, right, in the following year could have their salary fall below the threshold, thereby making it that they're not exempt any longer. And the problem with that, of course, is if they're not exempt, then they're entitled to meal periods and rest periods and overtime. And a lot of times we're not tracking, and properly so, tracking the hours of our exempt employees. And so the record keeping element is at fault there as well. So each year at the beginning of the year, it's wise to look at the new minimum wage, calculate the threshold amount for minimum salary, and then make sure everyone that we are intending to be exempt is paid over that salary amount on a salary basis. I thought we might just try to break this up a little bit with a little bit of opportunity to engage. So this is just a question. You can send in a response in the comments or in the question and answer area, if that's possible. I know there are some polling options, but that doesn't always work out perfectly. So I just one to think about here that we've covered a bit. A scenario. So the employees at this XYZ company receive a bonus at the end of the year. The bonus is provided on a completely discretionary basis. Does the discretionary bonus affect how overtime is calculated? Yes or no? I'll give you just a second to answer that question in the chat. Or you can answer it quietly to yourself. I see we're not many are interested in this question, it looks like. But
we have a couple responses, Trevor, coming through the question section.
What do they say there?
One says fully discretionary means quote unquote no, and then somebody else said no.
Yeah, I mean, and that's really the trick part of this question. Is it's very, very challenging to have a truly discretionary. So the answer is no, if it's truly completely discretionary. But and if you look at the second question, we won't go through that one, but if you look at any of the regulations on this, a bonus that has to do with performance or quotas or any type of incentive towards work performance, right, work production, then it's not discretionary. Despite the best efforts, at least from a wage and hour standpoint, it's not discretionary. And it needs to be calculated into that regular rate of pay, and it needs to be included in the calculation of overtime and meal and rest period. In fact, the regulations really only call out one truly discretionary bonus, and that is the old kind of proverbial Christmas turkey that you see in the old movies, right? That people would get a true gift that isn't based on performance or production or anything else. It's just a true gift to all employees. That does not have to be included in the regular rate of pay. But every other bonus, including, and this is one that sometimes catches people, those gift cards, right? A lot of times that's just like cash. And so those are part of the regular rate of pay and part of compensation that needs to be reviewed.
Trevor, we have a question that just came through.
Yeah, sure.
The question is, should a company that only has 2 1099 contractors have EPL insurance?
Yeah, that's a great question. And I think the answer has to do with, the nature of the contractor work. I'd have to refer back to Keck on some of the exclusions and whether they would deal with contractors or not. But my concern would be the misclassification issue. And because the misclassification issue is so prevalent, I would be concerned because those contractors can easily at least bring an employment type action. In fact, that's where all the misclassifications come from. And so the EPLI then would be able to help defend in that case. And part of the defense would be that they were contractors. So I think it's very, situation specific, and you want to talk to your broker about that fully. But I can definitely see where even if I believed I had all of my folks were contractors, looking at that EPLI and probably making an assessment based on how close to those 3 ABC rules I was. If I was really close to the line and there was a question about classification, then yeah, I would think that EPLI would be something you would want to really, really seriously consider.
And Trevor, I can jump in to answer regarding whether or not independent contractors are covered. It depends on your policy. So some policies, unfortunately, right, who is an insured and whether or not the insurance carrier includes an independent contractor as part of that definition of who is an insured. So each policy may be different. Some carriers exclude it, some carriers include it, and it just depends on what it is you're asking that carrier to include. So unfortunately, I wish I could say it's 100% included, but as we've learned, the market is hardening, and so carriers are limiting what they're covering.
Yeah. And that's why talking to the broker, looking at the details would be the right thing to do. But I mean, there's lots of contractors who are misclassified and they bring the employment claim. And so that's, that's what EPLI is for. Yeah. Excellent. Thanks,
We
Keck.
actually have a follow-up question for both of you, probably mostly towards you, Trevor. The question is, I have a mandarin orange grower for a tax client who pays individuals to work at his farm. Should they be treated as employees under the AB5?
Yeah, so I think, getting into the specifics and details of each employer will be challenging here on this, sort of broad scope. But what you're looking at there, and usually the issue that comes up, the ABC test looks at 3 things. The first is, are they independent, right? Are we controlling them is the next one. And then are they doing the work that we typically do? When you start talking about growers, start talking about individuals, the idea of them actually being independent and working for other people, the control that we have over them and the control that we exercise, we want them to do it our way. And then also that last one, are they doing our work, right? That we're growers, we grow stuff and they're picking our stuff. All of those, right, tend towards an employment relationship. And so in my mind, in general, that would be a tough one to be able to meet the ABC test. Now, there are some exceptions and there are some balancing tests that are still available on a limited basis. And so we'd want to look and see if those were still available to us in that industry. But by and large, if an employee, if a worker is doing our work and we're telling them how to do that work and they don't do it for anybody else, there's an exclusiveness associated with it, that becomes a very, very strong argument under the ABC test for an employment relationship.
Perfect, thank you.
Other question?
No, we're good to go.
Okay. Beautiful. So I see our time is growing thin here, and I recognize that we've spent a lot of time on wage and hour, but I tell you, that is a big place for you to spend your time as well. Let's run through some of the rest of these. There's not a lot of changes in leave of absence. This is a complicated area that I get calls on constantly on the compliance side, but there's not a lot of changes here this year. This case is a federal case that was helpful to the employer, and it did say that the employer's manner of calculating the 12 weeks for FMLA was appropriate, even though the employees didn't work a regular 12-hour work week. They were 1 week on, 1 week off, but this was favorable to the employer. And then the CFRA, which we did talk about, has been expanded again. Remember, last year it was expanded to go from 50 down to 20, and then it's actually applicable to anybody who has 5 employees. Very different than the FMLA. So this is 12 weeks unpaid for medical reasons of the individual, of a family member, and then adoption or birth of a child. And this law this year opens that family member element up to parents-in-law. I'm just going to jump through these questions. I think we've got to kind of run here a little bit more quickly. But leaves of absence, of course, are still a big issue, and I would make sure that your leave of absence policies and practices are strong. Equal employment opportunity, this is your discrimination, harassment, wrongful termination types of claims. Not a lot of changes here either. In this case, state law case, the employee had not properly identified the employer in some of the early complaint processes. The court basically shrugged its shoulders and said, well, they did it enough. It was good enough. And so you see that these claims, as we've always seen, right, in discrimination, harassment, wrongful termination, they're very favorable to the employee. And even if they don't check all the boxes perfectly, the employer does have to check all the boxes perfectly, and they are broadly favorable to the employee. This is just another example of that. In this case, this was actually a case with regard to kind of a third party who had conducted some training and used some racially offensive comments. So not just the employer, but the third party who was providing the training were found to have potential liability in this. And so even though the definition of employer has expanded, this actually expands it, in my mind, a little bit further to those who come in and may interact with our employees as potential defendants in a lawsuit for harassment, discrimination, wrongful termination. And it goes again to our obligation to protect the employees in the workplace, especially in training, but anywhere in the workplace, really, from unlawful harassment and discrimination. This is a new statute that is requiring certain courses, implicit bias. This, again, is a trend that I see over the last several years as we've done the required sexual harassment training for employers. There's a new element that requires us to train on basically bullying. And so this concept of expanding what is harassment, what is discrimination, right? Implicit bias means it's something that I might not fully recognize myself, but it is systemic. And there is an effort statutorily, and I think it'll follow in the courts, that we're going to try to eliminate that too. So not the overt discrimination, harassment, but now anything that might implicitly be so. And that's where this training is starting to come from, and we've seen that for the last couple of years. So policies, procedures, we need to get in early to this idea of what is harassment, what is bullying, what is happening in the workplace, and eliminate it before it gets to the point of unlawful action. This is just a law that extends the retention period. This has been our policy and advice for years, to keep things the full term of employment plus 4 years. 4 years is the statute of limitations for written contracts, and most employment law types of claims will be brought within that 4 years. There are some OSHA ones that are 30 years. I don't know how to deal with those other than those big outliers. 4 years after termination, separation, and is the retention of records idea. I'm going to skip these. Actually, you know what? I'm going to jump on these two real quickly, not ask the question, but these were two scenarios I thought were important. Number one is this ADA compliance of websites. We've seen a number of these cases where we used to see it's public accommodation, and it used to be there were lawyers that were coming in and trying to say, you know, your wall is too close to the toilet and the sink isn't right, and you'd have lots of these lawsuits for physical locations and proper compliance with ADA regulations. That has now moved to websites, and we've seen a number of these cases. My understanding, I'm not a techie guy, but it seems like when I've talked to folks, it's really making sure that there's a couple of buttons properly pushed on your website so that folks with disabilities, particularly those who are blind or deaf, members of the public, that they're able to access the website. So I would look at that, because I've seen a number of those kinds of cases and claims come through. The other one here is not any big changes in California law, but I continue to see drug testing and how do we deal with marijuana, which is legal at the state level and not at the federal. State law still permits us to rely on the federal mandate and prohibition, even with regard to marijuana. And I think the bottom line here is that, you know, we've had prohibited or controlled substances that are legal for a long, long time. Alcohol is one of those, right? Alcohol is a controlled substance, but we can still prohibit it in the workplace. Marijuana should be treated similarly. And so you might look at your policies, you might look at your testing obligations and see how you're dealing with marijuana, because I just see this question come up so much because of that conflict in state and federal law. A little bit more on agreements. This is a case where an arbitration was signed electronically, but the signature was not authenticated. I know lots of people are signing things electronically. Because it wasn't authenticated properly, the arbitration agreement was not valid. So make sure that as you're signing things electronically, you're making sure that the authentication will validate the agreement. Otherwise, that electronic signature is valueless. This is a case that kind of goes back to the arbitration argument again. And it basically says the state is not the employee. And so even if the employee signed an arbitration agreement, the state can still pursue its avenue. In this case, it was the labor commissioner for wage and hour violations. But the arbitration agreement did not stop the state, made the employee have to stop, but it didn't stop the state. So that's something to recognize, and I think may be addressed in some of these Supreme Court cases that are going to come down. Arbitration costs are outrageous, and I think this is maybe where I'll probably stop, but just to make this last point and then open it up for additional questions. This deck will be given to everybody, and you can go through the other pieces here. But arbitration, it continues to be quite expensive. It used to be much less expensive, but sometimes the arbitrator fees can be $20,000, $30,000, $40,000 in and of themselves paid up front. And this law actually makes that more costly because it says that you have to pay those, and the employer is the one who pays it, has to pay that invoice. It's an effort to try to not allow employers to, change the system and delay the process. So, but that becomes a big cost component of these arbitrations. And so whether arbitration is good or not is coming under question because it is becoming more costly. I'm not going to be able to address these. I want to open it up for questions. COVID, I've taken a solemn oath to stop scaring people about COVID. So I think many of you are aware of the statute of the Supreme Court, who did say that the vaccination mandate at the federal level was not enforceable with regard to most private employers, but is still effective in the healthcare industry. So that is a recent change, but I think we all are becoming fully aware of the COVID obligations. There are some changes that have occurred, but they're mostly at the fringes. And then, of course, labor law and union organizing. I think one just comment there, a lot of the policies that you have that deal with communication of your employees, whether it's electronic communication, whether it's confidentiality, whether it's communicating with outside third parties, the media, things like that, those are being scrutinized heavily by the labor board. And we need to make sure that those policies are properly written and protect the employee's right to communicate outside the workplace. All right, sorry for the time management issues, but I want to see if there's any questions out there. And thanks for listening in.
Thank you, Trevor. We do have some questions, of course. One is COVID related. Do you know the COVID sick supplemental 80 hours renewed this year?
It did not.
Okay.
I expected it to, actually. I really expected that. I was surprised that it did. So we're back to, I'll address that very briefly here. So we're back now to the Cal OSHA. The Cal OSHA rules are the ones that are in play right now at the state level. And the Cal OSHA rules say if there is an exposure at the workplace, right? Not anywhere else, but if it's at the workplace, then we have some obligations to send folks home, and we do have an obligation to make sure that their compensation is not harmed by that exposure and the time off. But we can use sick leave for that can come, but we do have to pay, but that's the only pay obligation, and it's only when there's an exposure at the workplace. So if you're exposed at school, at home, at the grocery store, whatever, and you have to take time off, that is not, we don't have to pay for that. But if there's an exposure in the workplace, then we are going to have an obligation to make sure that they are not harmed by the leave that they are required to take by us, by the Cal OSHA regs.
Wonderful, thank you. Another COVID-related question. Can an employer provide home tests that are available commercially?
Yeah, we actually had this question recently in another seminar that I did, and we did the background research. So Cal OSHA says it has to be, federally approved. And if you go and look, the home tests are, at least the ones we were looking at. And so that's what you want to check, right? If it's been approved by the federal system, then it is appropriate. Even home tests can be done. My understanding is there's complete scarcity of those. So the testing is challenging, but yes, I think by and large, any of the home tests that are being sold out there are going to be sufficient. Yep.
Perfect. I believe this is a follow-up question, but how do you prove it wasn't a workplace exposure when the employee is public facing?
Yeah, I mean, if you're saying that some member of the public gave it to them at work, I think that would still be a workplace exposure. But I think it's more on the other side, right? When you know someone has it, and then that group of people around, right? When an employee calls in and says, hey, I've got COVID, right? The exposure that we're dealing with employees is going to be just that group of employees that had close contact, right? So the initial exposure may not be, but the people then, the workplace mates that we have to send home and get tested and all of those sorts of things, that will be because of the workplace exposure, right? I think that's how it
Can
works.
I add one thing to it too?
Please.
When you have a COVID exposure, whether you know it's workplace or not, you are required to report it to your insurance carrier. So the carrier would do the investigation to determine whether or not it is a workplace exposure or somewhere outside of the workplace. So it's your responsibility to provide them with all the information they need in order to make that determination. They are the ones who will make that determination about whether or not it's workplace exposure.
Thanks, Kak. Another question that we have, I think this is more for you, Trevor. Are there special concerns or recommendations for employees paid on a piece rate basis?
Yeah, for sure. There's a statute that's a few years old now that makes piece rate very, very challenging to calculate because you have to take into consideration the rest period as not being hours worked and pay that separately. So there are some significant challenges with piece rate. Piece rate sometimes is used more as an incentive. And so it really is more of like a production type incentive compensation, a production bonus. That I think is maybe a better approach to pure piece rate. So have a base rate, which can pay, a minimum wage for employees so that you cover all those rest periods and all of that sort of thing. And then use the incentive compensation as a kind of a production bonus and not pure piece rate, because I think you want to avoid a purely piece rate type of compensation. It's doable, but it's quite complex, and you end up having to calculate an hourly rate for the rest period and paying that separately. And so it becomes just an administrative challenge, quite frankly. Yeah.
Perfect, thank you. We're gonna shut this down by 11:15, so we'll just fit in a few more questions. One of the questions came in, I believe it's for you, Keck, regarding reporting COVID cases to your carrier. Keck, did you say that you need to report all cases beyond SB 1159, regardless of whether there is a suspected workplace exposure?
Yes. Right now, the OSHA requirements and the carriers require that you report all COVID cases, and then obviously if it's not workplace related, they will not put it as part of your workers' comp claim, and they'll make that determination. But right now it is required that you report all COVID cases to your carrier.
Wonderful, thank you. Another question that's come through, can you clarify the meal breaks for employees? We have nursing staff, and if they work over 16 hours, how many meal breaks do they take?
Yeah, the healthcare industry has those challenges for sure, but it's basically 30 minutes for every 5 hours of work. And so when you get over 10, right, that it is requiring a second meal period. So 16 technically would get into a third meal period. Which is a pretty unusual in most industries. Sorry, not in healthcare, but in most industries that's pretty unusual. There is the ability to waive a second meal period as long as you've taken your first, and that should be in writing, and that's across the board. So that's what you'd want to look at but I think the key component really is to look and see what the schedule is. Look and see, what potential waivers there might be, and then get that into a strong policy. And I think into, if waivers are available, a written waiver, so that you're taking full advantage. And then you've got to police it. You've got to audit it. You've got to make sure that the employees are doing it consistent with the policy, and make sure that the time record and the payroll record and the policy all run perfectly together. Right. And so, I have some employers who just decide, look, I'm not going to deal with meal periods anymore, and I'm just going to pay the premium. That's fine. you can do that, right? Say, I'm never giving another meal period and another rest period. I'm just going to pay you the 2 hours extra as a premium. That's appropriate, but we need to make sure that the payroll records show that, so that we can, in an audit, it's just very record driven. And so we have to make sure our records, our policy, our records are all consistent and running together perfectly.
Wonderful, thank you. We do have a comment actually from a Bender teammate, Saul, who says, there's a difference between reporting a positive non-industrial COVID case and reporting a COVID claim. He wanted to make that stipulation. Would you agree?
Are you asking me?
I would say both you and Ken.
I know insurance has its own rules that are separate, right? From the statutes are talking primarily about internal notifications, and then we have some obligations to notify government at certain points if it's a significant enough exposure. I think when you're talking about insurance, right, that's contractual, right? And because you might remember back, right, at the beginning, there were some laws that were passed that tried to help the employers by saying there's basically a presumption that if you get COVID in the workplace, it's workers' comp. So for those reasons, I think the insurance industry as a whole, both workers' comp and in general, they want to know about everything that's happening in the workplace, because it does have potential liability issues for under the insurance coverage. So those rules are different than what is statutorily required of an employer, for sure. And I can see that there would be distinctions between those two, right? An industrial one versus just a general exposure of an employee and some type of claim, right? That may be based on a workers' comp. So, but I don't know the ins and outs of all of the insurance type disclosures that need to be made on the COVID stuff.
And I suppose in those situations, you could always contact Keck or your broker for more information.
Well, that's what I would do. That's exactly what I would do. I mean, in these situations that you want to talk to your broker, that's their realm. It's exactly what they need to help you figure out. Yep.
Perfect. Well, it is 11:15. We do have additional questions. However, we want to be sensitive to time. And so we will follow up with any of the additional questions that we did receive in emails. But we just want to thank, well, first of all, I want to thank both Keck and Trevor for sharing with us today. It was a wonderful webinar, such timely information, but we appreciate all of you for taking time out of your busy schedules to join us for today's BenderU. As a reminder, this session has been recorded, and a link to view and share the recording will be emailed to you following the webinar, along with a copy of today's slide deck. Again, we know this happens. If you have additional questions that pop up after the webinar has concluded, please feel free to reach out to us and we will be happy to help. Thank you again. We hope to see you at a future BenderU, and we all hope you all have a healthy, wonderful day, a wonderful week. And thank you again, Trevor. Thank you, Keck. Have a good one.